So welcome everyone. So today we will be starting with a very important topic of Bharatiya Sakshya Adhiniyam, and it is one of the most important evidence that plays a crucial role in any criminal trial or any civil trial, and that evidence is admission. So I will just explain you in a general words what you mean by admission. Admission means किसी चीज नू स्वीकार करना. सो ये तो हो गया ਇਹਦਾ जनरल मीनिंग. किसी चीज नू स्वीकार करना या किसी चीज नू इनकार कर देना. That is the admission. That is just, it can be given by oral statement or it can be given by written statement. जे गल करिए ਆਪਾਂ legal definition दी, so section 15 of the Bharatiya Sakshya Adhiniyam deals with the admission. Admission किया, it states that it is just a statement which can be made in three manner. First manner orally, second manner in written form, and third manner, which is new in Bharatiya Sakshya Adhiniyam, that is by electronic form, which was not provided under Indian Evidence Act. So as per the required circumstances, now even electric form of admission is also statutory recognized by the Bharatiya Sakshya Adhiniyam. So statement kiya, it is just a statement which can be made orally, in written form or in electric form, from which any inference in relation to relevant fact or fact in issue can be drawn. Inference kiya, anuman. Inference means your prediction. You can predict something from that statement in relation to fact and issue or in relation to relevant fact. So for example, if we look at a civil case, suppose there is a statement by A. He has not executed any sale agreement. So he states that B ਉਹਨੇ sale agreement ਨੂੰ execute नहीं ਕੀਤਾ है. So ਇਹਦੇ ਉੱਤੋਂ ਜੇ fact in issue ਇਹ ਆ ਕਿ if the fact in issue is that whether the sale agreement is being executed by A or not, so A statement to court की कर सकती है, the court can draw an inference. Inference means अनुमान या prediction in relation to fact in issue. Fact in issue किया whether A has executed sale agreement or not. So as simple as that, ਆਪਾਂ admission ਦੀ simple definition कर चुके हैं. You can note it down. ਜੇ ਤੁਹਾਨੂੰ ਕੋਈ ਵੀ short note ਆਉਂਦਾ ਜਾਂ ਫਿਰ ਕੋਈ preliminary exam ਚ question ਆਉਂਦਾ, it is as simple as that. Admission is a statement which can be in three forms. First one, it can be oral, it can be second form, it can be in written form, and third one, it can be in electronic form. ये होगी the introduction. So from that statement we can draw an inference in relation to fact in issue or relevant fact. So this is the basic definition of admission. So section 15 also provides that only admissions of the particular persons will be relevant. Only particular persons. It provides a list. So it states that made by any of the persons and under circumstances herein after mentioned. So हर एक इंसान दी या हर एक पार्टी दी admission relevant नहीं होगी. The persons who have been specifically mentioned under Bharatiya Sakshya Adhiniyam and particular circumstances, along with the particular persons and along with that particular circumstances, then only those admissions will be a relevant fact. ਹੁਣ ਆਪਾਂ admission ਦੀ definition ਤਾਂ ਦੇਖ ਲਈ ਹੈ. So let's see those persons, ਕਿਹੜੇ person ਆ ਤੇ ਕਿਹੜੀ circumstances ਆ, so that admission can be a relevant fact under civil or criminal trial. So section 16, it provides for the persons. So by which persons the admission shall be a relevant fact in relation to inference which can be drawn in connection with fact and issue or relevant fact. So let's take section 16, admission by party to proceeding or its agent. So it is as obvious as that if any party that is contesting a suit or in case of criminal trial any admission by an accused, that will be a relevant fact. So along with the parties also they are legally appointed agents. So the admissions given by the party or by their agent will be a relevant fact. Statements made by party to the proceeding or by an agent of such party whom the court regards under such circumstances of the case as expressly or impliedly authorized by him to make sums by them are admissions. ठीक है जी, ये तो हो गए persons. You got my point? ਜਿਹੜੀ ਪਾਰਟੀ ਹੋਊਗੀ ਜਾਂ ਉਹਦਾ ਏਜੰਟ ਨੂੰ ਲੀਗਲੀ ਅਥੋਰਾਈਜ਼ਡ ਹੋਣਾ ਚਾਹੀਦਾ ਵਾ. ਲੀਗਲੀ ਅਥੋਰਾਈਜ਼ਡ ਮੀਨਸ ਦ ਏਜੰਟ should be appointed by competent authority. ਜੇ ਏਜੰਟ ਲੀਗਲੀ ਅਪਾਇੰਟਡ ਹੀ ਨਹੀਂ ਆ then his admission will be of no use. Or the agent should have express or implied authority to give admission. So the persons हो गए दो. That is the party to the suit or their any agent. So let's now understand some circumstances under which admission will be a relevant fact. Statements made by parties to the suit, suing or sued in representative character, are not admissions unless they are made while the party making them held that character. So there are different types of suits under which some other person represent you. For example, under Order 32 of Code of Civil Procedure, when the person is a minor, he can't directly initiate or defend a suit. So he needs next friend. So ਇੱਥੇ next friend ਕੀ ਆ ਉਹਦਾ? ਇੱਕ representative ਆ. So admission made by that next friend who is acting as a legal representative of that minor person will only be considered as admission ਜੇ ਉਹਨੇ ਉਹ ਜਿਹੜਾ ਆਪਣਾ ਲੀਗਲੀ ਰਿਪਰੈਜ਼ੈਂਟੇਸ਼ਨ ਨੂੰ ਕਰੈਕਟਰ ਨੂੰ ਹੋਲਡ ਕੀਤਾ ਵਾ ਜਦੋਂ. ਸੋ ਫॉर ਐਗਜ਼ਾਮਪਲ ਵੈਨ ਹੀ ਇਜ਼ ਐਕਟਿੰਗ ਐਜ਼ ਅ ਨੈਕਸਟ ਫਰੈਂਡ, ਜੇ ਉਦੋਂ ਐਡਮਿਸ਼ਨ ਕਰੂਗਾ then that admission will be a relevant fact. ਜੇ ਉਸ ਤੋਂ ਪਹਿਲਾਂ ਕੀਤੀ ਜਾਂ ਬਾਅਦ ਕੀਤੀ that will not be admission. So that admission will not be of no use. So ਇੱਥੇ ਤੁਸੀਂ ਕੰਡੀਸ਼ਨ ਇਹ ਸਮਝਣੀ ਆ, if any person is representing another person in a suit, ਉਹਦੀ ਐਡਮਿਸ਼ਨ ਸਿਰਫ ਉਦੋਂ ਹੀ ਐਪਲੀਕੇਬਲ ਜਾਂ ਰੈਲੇਵੈਂਟ ਹੋਊਗੀ when that person is acting as that in representative character. ठीक है जी. So let's move to the another circumstance. Person who have any proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement in their character or persons so interested. So example, any person who has a proprietary or pecuniary interest in the subject matter of the proceeding. So for example, so there is a dispute regarding the ownership of some property. So dispute is going on. So there is a person who sold that property to the next party. So ਜਿਹੜਾ previous owner ਆ, ਜੇ ਉਹਨੇ ਕੋਈ admission ਕੀਤੀ ਹੋਈ ਆ ਪਹਿਲਾਂ ਦੀ while holding that character, ਜਦੋਂ owner ਸੀਗਾ, so admission ਜਿਹੜੀ ਉਹਨੇ ਕੀਤੀ ਆ that will also be a relevant fact. ठीक है जी. Persons from whom the parties to the suit have derived their interest in the subject matter of the suit. So for example, ਇਹਦੇ ਚ ਆਪਣਾ order 22 ਹੈ ਜਿੱਦਾਂ. So for example, order 22 of Code of Civil Procedure which deals with the death of the parties. ਜਦੋਂ parties ਦੀ death ਹੋ ਜਾਵੇ then legal representative on the record continues the suit. So for example, ਜਿਹੜਾ ਆਪਣਾ the person who is deceased and the legal representative has joined the suit, ਜੋ ਵੀ ਉਹਦੀ ਪਹਿਲਾਂ ਦੀਆਂ admissions ਕੀਤੀਆਂ ਹੋਣਗੀਆਂ, the person who has been died, so those admissions will also be relevant in a suit that is being continued by the legal representative. ਠੀਕ ਹੈ ਜੀ. ਹੁਣ ਇੱਥੇ ਆਪਾਂ 3 circumstances ਦੇਖੀਆਂ ਤੇ 2 parties ਦੇਖੀਆਂ under section 16. Under section 16 दो person हो गए, that is the party to the suit or any agent who has been legally appointed with them. So इन्हां दियां admissions will be a relevant fact, and along with that ਆਪਾਂ तीन circumstances पढ़ियां that we have discussed in detail. So you have to learn this section 16. It is very important section if we look at preliminary point of view or a mains point of view. It is very important section. तो इत्थे तुहानू क्वेश्चन डायरेक्टली मिलता, who are the persons who are eligible to give an admission or what are the circumstances under which admission will be a relevant fact. So तुसी section 16 नू चंगी तरह पढ़ना. If you feel any doubt you can message me or you can just drop down comment below. So section 17 नू देखिए आपां, admissions by persons whose position must be proved as against party to the suit. So section 17 deals with that admission जे बंदा जिहदी liability ते depend करे सूट, जो ओदी admission होगी that will also be a relevant fact. So इनू मैं थानू illustration नाल समझाउणा which has been given under our BSA Act. A undertakes to collect rent for B. A appoint हो गया B ਦੇ ਲਈ rent collect ਕਰਨ ਲਈ. B ਦੀ properties ਨੇ, so he has a lot of properties, so he appointed A to collect rents. B sues A for not collecting rent due from C. ਤੇ B ਨੇ ਹੁਣ A ਤੇ sue file ਕੀਤਾ that he is not discharging his duty and he is not collecting rent from C. But A denies that rent was due from C to B. A ਕੀ ਕਹਿੰਦਾ ਵੀ C ਦਾ ਕੋਈ rent due ਹੀ ਨਹੀਂ ਸੀਗਾ ਤੇ ਮੈਂ ਕਿੱਦਾਂ collect ਕਰਾਂ. A statement by C that he owed rent B is an admission. ਹੁਣ ਜੇ ਇੱਥੇ C ਦੀ ਜਿਹੜੀ liability ਹੈ that is in question. ਹੁਣ ਜੇ ਇੱਥੇ C ਕਹਿ ਦੇਵੇ ਵੀ ਮੇਰਾ ਤਾਂ rent due ਹੈਗਾ ਵਾ, even though C is not party to the suit. ਸੂਟ ਕਿਹਦੇ ਵਿਚਕਾਰ ਆ? A ਤੇ B ਦੇ ਵਿਚਕਾਰ ਆ. A ਨੇ rent collect ਕਰਨੇ B ਦੇ behalf ਤੇ, and so B has filed suit against A for not discharging his duties, so that he has not collected rent from C. ਠੀਕ ਹੈ, ਤੇ ਇੱਥੇ ਜੇ C ਕਹਿ ਦੇਵੇ ਵੀ ਮੇਰਾ ਤਾਂ rent due ਹੈਗਾ ਵਾ, so that admission will be relevant under section 17 of the Bharatiya Sakshi Adhiniyam, even though C is not party to the suit. क्योंकि ਆਪਾਂ जनरल rule A पढ़िया ना, only the party to the suit can make an admission, only the admission by party to the suit will be a relevant fact. But section 17 is an exception where the admission of third person is also being held relevant. So the condition is that his liability is in question. The third person the liability question ja do parties ਦੇ suit ਦੇ ਵਿਚਕਾਰ, then admission by that third person will be a relevant fact. ठीक है जी. So let's move to section 18. Admissions by persons expressly referred to by party to suit. So for example, ਜੇ ਆਪਾਂ ਕਿਸੇ ਪਾਰਟੀ ਤੋਂ ਕੋਈ ਕੁਐਸਚਨ ਪੁੱਛਿਆ, ਉਹ ਆਪ ਆਨਸਰ ਨਹੀਂ ਕਰ ਰਹੀ, he said that ਵੀ ਜਾ ਕੇ ਉਹ ਤੋਂ ਪੁੱਛ ਲਾ, ਥਰਡ ਪਰਸਨ ਤੋਂ ਜਾ ਕੇ ਪੁੱਛ ਲਾ, ਐਕਸਪ੍ਰੈਸਲੀ ਮੈਂਸ਼ਨ ਕਰ ਰਿਹਾ. ਠੀਕ ਹੈ ਜੀ. suppose there is a contract deal between A and B. A is the seller of the house and B is the buyer of the house. ਠੀਕ ਹੈ ਜੀ. A ਨੇ ਸੈਲ ਕਰਨਾ ਆਪਣਾ ਹਾਊਸ ਤੇ B ਹੈਗਾ ਬਾਇਰ. ਹੁਣ B A ਨੂੰ ਪੁੱਛ ਰਿਹਾ ਵਾ, B is asking from A, is there any mortgage deed on that house? ਵੀ ਕੋਈ ਇਹਦੇ ਤੇ ਇਨਕੰਬਰੈਂਸ ਤਾਂ ਨਹੀਂ ਗਈ. So buyer is just making general inquiry. A ਤੋਂ ਪੁੱਛ ਰਿਹਾ ਵੀ ਇਹਦੇ ਤੇ ਕੋਈ mortgage ਤਾਂ ਨਹੀਂਗਾ, ਡੈਟ ਤਾਂ ਨਹੀਂਗਾ ਹਾਊਸ ਤੇ A ਇੱਥੇ ਆਪ ਆਨਸਰ ਨਹੀਂ ਦਿੰਦਾ. A ਜਾ ਕੇ ਕਹਿੰਦਾ ਮੇਰੇ ਸਨ ਤੋਂ ਪੁੱਛ ਲਾ ਜਾ ਕੇ, C ਤੋਂ. ਠੀਕ ਹੈ ਜੀ. C ਤੋਂ ਜਾ ਕੇ B ਪੁੱਛ ਲੈਂਦਾ. ਸੋ B is a buyer, ਉਹਦਾ ਰਾਈਟ ਆ, ਉਹਨੇ ਇਨਕੁਆਇਰ ਕਰਨਾ ਵਾ, ਉਹ ਜਾ ਕੇ C ਤੋਂ ਪੁੱਛ ਲੈਂਦਾ, is there any mortgage or any debt? So C says that there is no mortgage, no debt. ठीक है जी. So that admission made by C will be relevant against A, who is a seller of the house, even though उन्हें आप admission नहीं की, but because he has expressly mentioned भी तू C तो जाके पूछ ला, so that admission by C, the son of A, will be relevant if there is a dispute between A and B regarding the debt or mortgage on that house. ਉੱਥੇ C ਦੀ ਜਿਹੜੀ statement ਹੋਗੀ, that will be held relevant as an admission between suit of A and B. You got my point? 17 section 17 and section 18 की ने, so these are the exceptions. ये exceptions ने section 16 दी. General rule किया, only the parties or their agents can make admissions in a suit, but section 17 provides for the third person where the third person's liability is in the question. ते section 18 जिथे party expressly mentions that, expressly allows the third person to give admission on his behalf. So section 17 and 18 are the exceptions of the section 16. ठीक है जी? So in that process we have completed what is an admission, how who makes the admission, and under what circumstances admission is made, and along with that we have read two exceptions in form of section 17 and section 18. ठीक है जी? Tomorrow we will study what are the self-serving admissions and what are the self-harming admissions, and which type of admissions will be relevant under भारतीय साक्ष्य अधिनियम. ਆਪਾਂ टाइप्स ऑफ एडमिशंस पढ़ांगे जो कि सेल्फ हार्मिंग भी हो सकती है, इट कैन बी सेल्फ सर्विंग भी हो सकती है. ਤੇ ਆਪਾਂ ਬਾਅਦ ਚ ਦੇਖਾਂਗੇ ਵੀ ਕਿਹੜੀ ਐਡਮਿਸ਼ਨ ਆਪਣੀ ਰੈਲੇਵੈਂਟ ਹੋਊਗੀ ਜਾਂ ਕਿਹੜੀ ਐਡਮਿਸ਼ਨ ਰੈਲੇਵੈਂਟ ਨਹੀਂ ਹੋਊਗੀ. ਠੀਕ ਹੈ ਜੀ? So today we have completed very important concept, that is an admission. ਆਪਾਂ ਐਡਮਿਸ਼ਨ ਦੀ ਡੈਫੀਨੇਸ਼ਨ ਕੀਤੀ ਆ. ਜੇ ਤੁਹਾਨੂੰ ਐਡਮਿਸ਼ਨ ਦੀ ਡੈਫੀਨੇਸ਼ਨ ਦੇ ਵਿੱਚ ਕੋਈ ਡਾਊਟ ਆ ਜਾਂ ਕੁਐਰੀ ਆ ਜਾਂ ਐਨੀਥਿੰਗ, you can drop down comment or you can message me. So after that ਆਪਾਂ ਇਹ ਵੀ ਪੜਿਆ ਵਾ who are the eligible persons to make an admission. After that we have studied the circumstances, the three circumstances under section 16. So where admission can be made, and after that we have taken two exceptions of section 16, that are section 17 which provides for the admission by an third person where his liability is in question between the two parties, and after that section 18 where party himself allows any third person or gives authority to any third person to give admission on his behalf. So that is section 18. So ਇਹ ਆਪਾਂ ਬਹੁਤ ਹੀ important topic discuss ਕੀਤਾ ਵਾ. So tomorrow we will discuss what are the types of admissions and how they are relevant under भारतीय साक्ष्य अधिनियम.